Hello, good afternoon and welcome to today's CLE webinar. Legal Aid Queensland acknowledges and respects the First Nations custodians of the land where our offices stand and where we work to help disadvantaged Queenslanders uphold their legal rights in our justice system. We pay respect to their elders, law, customs and creation spirits. We recognise that these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role Aboriginal and Torres Strait Islander peoples play in our community and improving our legal system. So welcome again, my name is Kiara. Apologies that I'm off screen. Today's webinar is helping clients navigate separation. It will be presented by Marianne, who is our Director of Family Law Services here at Legal Aid, Amanda, the Senior Family Dispute Resolution Practitioner, and Marie, our Referral Pathways Officer. So thank you so much for coming here today and presenting, and also thank you to our interpreters. Just a little bit of housekeeping before I hand it over to our presenters. This webinar is being recorded and it will be available on our YouTube channel. The laws and content is accurate on the day of the live presentation and may change. Information is on our Community Legal Education Resources page on the Legal Aid Queensland website. If you are having any technical difficulties, you will need to contact the GoToWebinar customer support team. Unfortunately, I'm unable to assist. Today's webinar is a little bit different from our usual structure. It is slightly longer. We will have about 40 to 60 minutes of presentation time with a 20-minute Q&A at the end. We do ask that you hold off on any questions until the end of the webinar and pop all those questions into the chat box. So the chat box can be located on the bottom, and we are using a new platform. So if you need to pop it into the questions box, you can do either, but preferably the chat. You are also able to access a PDF copy of today's presentation slides in the handout section, but I'll also email you a copy of the slides after the presentation. So just a couple of quick polls to get us started. So the first one is, which region do you work in? Southeast Queensland, Far North Queensland, Regional Queensland, or outside of Queensland? And I'm just launching that poll. Give you a couple more seconds to respond. Okay, and I might close that one off now. Okay, so we have about 59% are from Southeast Queensland, 16% from Far North, 19% from regional, and 6% from outside of Queensland. So for that one, is most of our content here subject to Commonwealth or Queensland law, Mary?
Commonwealth, if
okay.
We're talking about family law, yes.
Wonderful, okay. And all of our services, obviously it's for Legal Aid Queensland, but we can still, still the information will still be helpful today. So just one more poll before I hand it over. Okay, so this poll is, what is your role? Support worker, financial counsellor or health education worker, social worker, lawyer or other? And I'll just keep it open for a few more seconds. And thank you to everyone as well for engaging with the polls. It's really helpful for our presentation. So I might close that one off. So 6% support worker, 22% financial counsellor or health worker, 14% social worker, 28% lawyer, and 31% other. So that's interesting. It's a good mix today. And I'll just share that for everyone watching. Perfect. So what you'll learn today, first, Amanda will go through our dispute resolution services. Then she'll hand it over to Marianne, who's going to go through our family law services. And Marie will finalise it with our referral pathways program. So with that, I'll hand it over to Amanda.
Thanks, Kiara. Hi, everyone. I'm going to start today by explaining some of the terminology that we use in family dispute resolution just in case you're not aware of that. So next slide, please. Thank you. So the terms conference, mediation, FDR, and family dispute resolution are all interchangeable in family law. So you'll find that Legal Aid Queensland uses FDRC, so Family Dispute Resolution Conference, or the word conference. And you'll find that the Family Court uses the term family dispute resolution or court-based dispute resolution event. But these are all the same things. It's a family law mediation. So the next terminology I wanted to talk about was FDRP and mediator. So an FDRP is a family dispute resolution practitioner, and a mediator is slightly different. So they're not quite the same thing, but they both perform mediations. A family dispute resolution practitioner is a specialist family law mediator. So they have to be accredited under the Family Law Act, and they're registered with the Attorney General's Department. Only a family dispute resolution practitioner can issue the certificates that parties need to be able to make an application to the family court about children's matters or about property matters. A mediator is a bit more broad in their scope of work. So you might find that mediators can do civil disputes, neighbourhood disputes like fencing issues. They could do commercial disputes as well. They might be accredited by organisations like the National Mediator Accreditation Standards. But both a mediator and an FDRP are independent, and they work with parties at a mediation to help them identify what it is that they want to talk about, what they don't agree about, and what they do agree about. So the three things I'm going to talk to you today about is the law around family dispute resolution, an overview of dispute resolution services at Legal Aid Queensland, and eligibility for grants of aid for family dispute resolution at Legal Aid. So first off, the law. The Family Law Act requires parties to attempt to resolve their disputes via family dispute resolution before they make an application to the family law courts. For this reason, dispute resolution services at Legal Aid is often the first port of call when clients come to Legal Aid and make an application for funding. When a person applies to Legal Aid for family law matters, our grants officers who assess those applications have to consider whether it's appropriate to refer the matter to dispute resolution services for a family law conference. So when we're talking about disputes in family law, we're talking about parenting matters, about children, or we're talking about property matters, which can be about separating a party's financial arrangements after separation. And the legal requirements for actions that separated parties need to go through prior to filing an application in the family court are a little bit different for parenting or children's matters versus those property or financial matters. So for children's matters, parties are required to attempt family dispute resolution unless the matter falls within an exemption category. And from June 2025, it's really important to note that the court won't even accept an application unless, about children's matters, unless the parties file their certificate confirming they've attempted family dispute resolution, unless the court grants an exemption. Now, matters like recovery applications, or if someone's trying to take a child overseas, or a matter where there are significant allegations of child abuse or domestic and family violence. In those types of matters, the court may say that the parties don't have to wait and attempt mediation before the court accepts their application. So in property matters, it's a little bit different. The court says the parties are required to make a genuine effort to agree, and it says that they need to make inquiries about and invite the other party to participate in dispute resolution where it's safe to do so. So you can see that that obligation is a little bit looser in wording, and there's no requirement for a certificate to be filed with the application. But the court still focuses heavily on these obligations, and it also requires the parties to file information about how they've complied with these obligations. So the second thing I want to talk to you about is an overview of our dispute resolution services programs at Legal Aid. We have 3 programs. The first is Family Dispute Resolution Conferences, which deals with children's matters or children and property matters. The second is Property Only Conferences, which, as the name suggests, deals with property only disputes. And the third is Family Law Property Arbitration. So arbitration, whilst still being a dispute resolution event, is not the same as mediation. In a mediation process, the parties are the decision makers and the mediator helps them to have discussions about what their agreements might be. But in an arbitration, a specially trained lawyer makes the decision for the parties and the parties have agreed to participate in that process. So effectively, the arbitrator sits in the shoes of the judge and makes the decision for them. This is just some information about our dispute resolution services at Legal Aid. Essentially, what we're doing is giving families the opportunity to meet and talk and help resolve their disputes. All 3 programs we run are consent-based. So what that means is that all parties need to say that they agree to be part of a mediation for us to arrange one, and the same applies to arbitration. And any party can remove their consent at any time and withdraw from the process. We work with a panel of over 50 FDRPs and 16 arbitrators, and just for some stats, we held about 800 conferences last year. So a common myth is that mediation cannot occur if there's a domestic violence order in place, but that's not the case at Legal Aid. We will conference a matter if there's a protection order, and we take steps to ensure the party's safety and to make sure there's no breach of any order. So this would include if there's a final domestic violence order, a temporary domestic violence order, or a police protection notice or a police protection direction. We have an ongoing screening and assessment process, so that's throughout intake, and a lot of information is gathered from the participants to assess whether the conference process is suitable and to make sure that everyone's safe. And what we're really looking for there is to make sure that everyone who attends a mediation or arbitration can participate in the process freely. If a matter is assessed as not suitable to proceed, the certificate will issue that I talked about before, but that will state that the conference was inappropriate. That can occur before a conference is held, or it can happen during a conference if information comes to light. There are some other reasons why we might say a conference is not suitable. It could be things like health issues for the parties, or it's impractical to hold a mediation. And the certificate will never say the reasons why the conference didn't go ahead. It just says the information that's prescribed by law. So our first program is Family Dispute Resolution Conferences. As I said, these conferences can be held about children's only disputes or disputes about both children and property, and that includes adult child maintenance. Our conferences are lawyer assisted, which means that the person who applies to Legal Aid will have a solicitor funded by Legal Aid, provided that the other party agrees to attend the conference. The other party can attend self-represented, or they can pay a private solicitor to attend with them. The format we're using is primarily Microsoft Teams, although we do have some that are telephone and face-to-face, but that's very few. And we also have joint or shuttle formats available. And what that means is that if there's concerns about safety or a domestic violence order in place, we can arrange a shuttle mediation where the parties don't see or speak to each other throughout, and the mediator moves back and forth between the meetings. If the parties all agree and it's safe, they can be in a joint format, which means that everyone can see and hear each other. So our next program is the Property Only Conferences. This is an excellent option for people who have smaller property pools or for separated parties that don't want to go through the court process. We offer up to 2 conferences of a maximum of 5 hours in total. And the way this ordinarily works is an initial conference for up to 3 hours, where the parties start their discussions and they can identify if they need any further information or disclosure. oftentimes parties will need to go away and get more documentation or valuations. So after that initial conference, they can have a break and come back perhaps a few months later and have a second conference for 2 hours to see if they can reach an agreement. At property-only conferences, the parties must be represented and they must be able to tell us that there's no substantial children's dispute. This doesn't mean that they have to have orders or a written agreement in place about parenting matters, but it does mean that both parties need to agree that they don't need to talk about children's matters. One party must be legally aided to go ahead, and the other party can come along with a private solicitor that they pay for, or if they're eligible for legal aid, they can attend with a legally aided solicitor. And the formats for property conferences are the same as for family dispute resolution conferences. So this is just some information about our conferences generally. At a legal aid conference, the parties are encouraged to talk to the FDRP directly. We find that this means that the parties feel they have more control over the process and they're more invested in the outcome. Lawyers are there to assist with proposals and the specifics of the negotiations, and they're there to support their client. We also offer interpreters if they're required, and legal aid would fund any interpreters for legally aided parties and for self-represented parties. Support people are available if they're requested, but the support people are required to be silent during the mediation process, and they don't advocate on behalf of the person they're supporting, and they don't engage with the FDRP. So our third program is the Family Law Property Arbitration Program. Like I said, while this still is a dispute resolution process, it's different from a mediation. It's an excellent option for small property pools and if the parties can easily identify what's in the pool. For example, if the parties have a home that they own between them and there's some superannuation or money in the bank, and it's a small pool that will be easy to divide. It's a low cost and less formal option than going to court. So in an arbitration, the arbitrator decides the property settlement for the parties by issuing them with an award. And that's a written document that's like a court judgment that explains the reasons why those orders should be in place. And the parties then enter into consent orders that are in the same terms as the award. So this slide is just some requirements for arbitration and some further information about it. Again, the parties need to be able to tell us that there's no substantial children's dispute to be eligible for arbitration, and both parties must be represented. Again, it can be one legally aided party and the other party can come with a private solicitor if they're not eligible for legal aid. The format for arbitration is different to mediation. So arbitration is heard on the papers, which means that the lawyers send information to the arbitrator and the arbitrator makes the decision based on that information. There's no meeting or process where the parties have to come into contact with each other. There is the option for oral submissions though, and the lawyers can opt into that, and that's where they would have a telephone meeting with the arbitrator and provide further information. But there's no cross-examination of any party. The timeline for arbitrations is about 4 to 6 months, and that's opposed to possibly years in family court proceedings. So the next thing I wanted to talk about was eligibility for grants of aid for these programs because they're a little bit different. Family dispute resolution conferences, so that's our children's conferences or children and property combined conferences, they use the usual means and merit test from legal aid. But the property-only conferences and the Family Law Property Arbitration Program have an increased asset test. The next slide, please. Thank you, Chiara. So more specifics about the eligibility for FDR conferences. Legal aid requires that the parties are separated for 6 weeks and they apply the usual means and merit test. So in terms of merit, it's that there's a substantial dispute. And for the means test, our grants officers apply an income and assets test. Eligibility for the property conferences and property arbitration program. Parties also need to be separated for 6 weeks, and they need to have been in a married or de facto relationship, so they fall within the jurisdiction of the Family Law Act. Now, you will have noticed that being in a married or de facto relationship was not a requirement for family dispute resolution conferences about children's matters, and that's because any person with standing to make an application to the court falls within the jurisdiction of coming to us for children's matters. And so that can include grandparents, extended family members, it's anyone significant to the child. So that's a little bit different for property conferences and family law property arbitration. They also need to fall within the statutory time limits or have leave to apply out of time been granted by the court to fall within these programs. So the asset pool is a bit different for family law property arbitration and for property conferences. You can see there that the asset pool needs to fall within $20,000 to $500,000, excluding superannuation, or the legally aided client's claim is $250,000 or less of a net pool that exceeds $500,000, excluding super. There's no limits on superannuation, and it's not included in estimated total net equity. So that's an increased asset limit when compared with Legal Aid's normal asset test. And what that means is that there may be people who are eligible for our property programs that may not have thought they were eligible for Legal Aid. There are some exclusions to our property programs that you need to know about as well. So we don't deal with any business or commercial undertakings. We won't deal with matters that have a third-party unsecured debt. So that's a situation where, for example, mum or dad of one of the parties has loaned them an amount of money to buy a family home. We won't deal with matters where there's trusts involved or where it's a debt-only pool. It's important to know also that property conferences and arbitration at Legal Aid are not free. So both the legally aided party and the privately represented parties will be asked to contribute towards their costs. And for legally aided parties, this is done by way of a retrospective contribution. So what that means is we would ask for a contribution back to Legal Aid after the party has received their property settlement. We do have some resources in the Dispute Resolution Services section that are specific to us. And this one might look familiar to many of you. It's our fact sheet about need help to sort out a family law problem. That fact sheet talks generally about our family law conferences. We also have fact sheets for our other programs, Your Property Conference and Your Property Arbitration, and all of our resources are available on the Legal Aid website in the publications section. The next resource we have that's specific to dispute resolution services are the step-by-step process maps for clients. So we found that clients had questions that perhaps weren't answered by the fact sheets, and this might help clients who might deal with information in a visual way rather than wanting to read a lot of text, and they're easy step-by-step maps for each of our processes. So the third resource we have that's specific to dispute resolution services are our YouTube videos. These are available on the Legal Aid website as well as in our YouTube channel. We have short videos for each of the dispute resolution services programs. And again, this might assist some of our clients who are more visual learners, and it's a great resource to help them understand what to expect in our dispute resolution services programs. So that's all from me in relation to dispute resolution services. I'll now hand over to Marianne.
Thanks. Hello, everybody. I just wanted to start out by explaining how Legal Aid Queensland can help people with their family law matters. And it's the staged approach you can see from the slide there. The first point is about accessing information and referrals. And that can happen when somebody has some questions about their matter and they might just need to find out some information about what their next steps might be. The second level of assistance that Legal Aid can provide is legal advice. So that legal advice can be a short legal advice, or it can be a longer specific legal advice with a particular area of practice in the family law practice, so DV, child protection or family law. The third level of service that we can offer at LAQ is a duty lawyer service. So that's having a lawyer available at your court appearance if you're in court for a matter, and that includes for family law, for a domestic violence court, or for a child protection matter. The fourth level, of course, is legal representation in court. So that is where eligible, the client will receive a grant of aid to have a lawyer either from Legal Aid or from one of our preferred suppliers who act on behalf of clients of Legal Aid to represent them in their court matter. And again, that occurs across each of the jurisdictions: family law, child protection, and domestic violence. So legal representation in court is under a grant of aid. And that's the fourth point there, is getting a lawyer to represent you. So that's the opportunity for having a lawyer to assist you throughout the course of your litigation in whichever court that it's happening. So there's heaps of information that you can find out about from Legal Aid Queensland's websites. You'll see there, that's the front page of the Legal Aid website. And if you click into that, there is information that you can access, which includes information about the services that Legal Aid provides, legal information about various areas of law, particularly in family law, but also across our civil and our crime practices at Legal Aid. And there's also information about how to contact Legal Aid Queensland to access our services. I wanted to highlight too that Legal Aid's website has a bunch of information pages and publications that are relevant. And I'd suggest that clients, if they're wondering about what they should do about their legal matters, this is a great place to start. You can see from the slide there that it's easy to access. There's information about relationships and children, which is family law matters and the like, domestic violence, children and parenting, child support and maintenance, and there's also information about crime matters and police matters and their rights. So that's the first landing page from our website that gives you some basic information so that clients can understand what their next steps might be and where they might need to go to get further information or representation. We've also got an absolute bounty of information and publications. You can see there that there is a publication which talks about whether a person can get legal aid, and that's a really good place to start in figuring out whether or not a client will be eligible for legal aid. There's booklets about all sorts of information. The one that I've highlighted there is about consent orders in parenting matters. And there's also lots of information in the jurisdictions for domestic violence and for child protection. So they're a really good resource to get some information about what the process might look like, to see whether or not you can access legal representation. So I urge everyone to consider looking through those information and publications as a start point to figure out their next steps. After that's occurred, Legal Aid does have access to initial help for clients. Our 1300 number is the number that will get you into our call centre or contact centre, and the people who staff the call centre will be able to assist clients in identifying the problem that they have, providing them with information and referrals, assisting the clients to work out what their next steps might be, and the call centre or contact centre can make some bookings for a very short initial legal advice with the First Advice and Contact team at Legal Aid, and that can give clients a really good first understanding of what their problem is, what they might need to do, whether or not they should apply for legal aid for assistance, and if the First Advice and Contact team identifies that it's a more complicated matter that might need more specialist advice, then referrals can be made to specialist clinics run by the family law practice at Legal Aid. So the specialist clinics run in Brisbane, and clients can be booked into those clinics. There's clinics for family law advice, there are clinics for child protection advice, and there are clinics for domestic violence advice as well. And clients can be booked in to get some legal advice from those specialist groups in the practice. Also, if a client comes in through our 1300 number and they need assistance from a duty lawyer service, then they can be referred to the appropriate duty lawyer service at the courts around South East Queensland and across Queensland more generally. So if they come through the call centre and they are looking for a duty lawyer for their matter, which might be in court in the next couple of days, the 1300 number can refer those clients to the appropriate duty lawyer service across Queensland. The other thing that we have, which I've mentioned, is that we do have specialist advice clinics at Legal Aid. They fall across the family law practice into the three areas that I've discussed. We have a family law advice clinic, and we have a child protection clinic and a domestic violence clinic. So we can give advice to clients about their issues in each of those different jurisdictions. And I've listed them out there on the slide. The one that I've not spoken about yet is a child support clinic. There's a small group in the family law practice in Brisbane who is able to provide advice and assistance to parties who might have concerns or questions about their child support matters. And there is a clinic that runs one day each week in Brisbane to give advice for parties who might have some issues with their child support. So they're telephone clinics, as I've discussed, and what happens is that when they are booked into the clinic, the client will provide a small amount of information at the beginning so that the lawyer who is assisting that client has a little bit of understanding about what the problem is, so that they can then make sure that they are giving appropriately tailored advice for that client. And when the advice is occurring, the lawyer will provide advice about the specific legal problem that they have. They might send them some fact sheets and other information. They might provide them with some ideas about what their next steps might be. And they may also suggest that they make an application for legal aid funding to get a lawyer to assist them with their matter. The next step, or the next stage, is around help at court for clients. So if there is a person who is involved in a matter, either in the family court or in the child protection jurisdiction or in the domestic violence jurisdiction, there are they can access help at court from Legal Aid Queensland lawyers, and that's the duty lawyer service. So there's, as you can see from the slide there, there's a few duty lawyer services available. The first one is a domestic violence duty lawyer service, and that happens across lots of magistrates' court across the state, and Legal Aid provides duty lawyer services either from folks who are employed by Legal Aid or preferred supplier firms, so lawyers that Legal Aid engage to perform the duty lawyer work across Queensland in the domestic violence space. The other assistance program that's mentioned there on that slide is the Application Assistance Program, and that's in the Brisbane Domestic Violence Courts, usually on a Friday, where if there is somebody who needs assistance to draw up or write their application for a domestic violence order, there are support workers available at Brisbane on Fridays to assist those clients to fill out and have their application lodged with the court. The other specialist duty lawyer service is, of course, the Child Protection Duty Lawyer Service, and the Family Law Duty Lawyer and FAST service is also available all across Queensland. So when clients present to a duty lawyer assistance, the services that they will receive will be a lawyer assisting them by identifying what their legal problem is, working out what their options might be, giving them some advice and information about what their problem is, explaining to them if they're in court and needing to appear before the court on that day, explaining what will happen, explaining if they need to be representing themselves, what they might need to say, what might happen with the other party in court, what to expect from the court on that day. Duty lawyer assistance can sometimes extend to helping clients with writing up some documents, helping them to fill out an application form for legal aid, and assisting with some simple court forms. Duty lawyers also will refer clients to other organisations who might be able to help with their issues, such as domestic violence support services and the like. In some circumstances for duty lawyer assistance, that can extend to a duty lawyer appearing on behalf of the client, negotiating with the other person or their lawyer to see whether or not there can be some agreement reached, or to work out whether or not there can be some agreement about what the process should be in the litigation going forward. That's a really difficult map to see from on a webinar. I'm sorry, but I had to kind of squish it down so that it fitted in. But that's just a really useful identification of where Legal Aid provides duty lawyer services in Queensland courts. That's not just family law or domestic violence and child protection. That's all of the criminal courts that we also visit and provide duty lawyer services for. It is on our website, so if you're interested, you can probably access that in a much more full way on our website. But that just demonstrates that there's a lot of duty lawyer services that Legal Aid Queensland provides across Queensland. So if there are clients who need to see a duty lawyer, it's really important that they understand what the service is and how to access it. So it's good to go through the steps in the previous slide, get onto the Legal Aid website, figure out what service you might need or what service the client might need. Get some advice and information from our website before you attend at court as a client, because that makes you more prepared and hopefully feel more confident that you're going to get a good outcome on the day. Always arrive early for the duty lawyer service or your court appearance so that you can be settled and ready, and make sure you bring your relevant documents with you so that if you are accessing a service, the lawyer has a bit more information to provide much better advice and assistance at the duty lawyer service on the day. So there's a lot of information on Legal Aid's website about the duty lawyer services that are available in each of the areas of domestic violence, child protection and family law. And that's the page about the child protection duty lawyer, but there's also a page about each of the other duty lawyer services on the Legal Aid website. And as you can see there, after the webinar today, we'll share some links about the information that each duty lawyer service provides and where after the recording. So getting a lawyer for your case, having a lawyer appointed to represent you in your case is the next level of service that that Legal Aid can provide. And I've put up a fact sheet there. It's important to understand that Legal Aid has got some constraints when allocating funding for a person to be represented or have a lawyer represent them in their case. So on the screen, on the slide there, there's considerations that Legal Aid needs to determine when they're allocating funding for a case. And the first is about the means test. So that is examining whether or not a person seeking to get funding falls within the income guidelines and the asset guidelines to be able to be funded. So that's the means test. The merit test is also the test which determines whether the case is likely to be successful. So it's important that, if Legal Aid is providing funding, that it is for a proper purpose and that, that the client is likely to succeed in getting what they are asking the court to give them. So it's important to understand that Legal Aid has got funding guidelines, and you can certainly access information about that from our website. To be able to get a lawyer for your case, you need to make an application, and the picture there is a copy of the application form for Legal Aid. If there is a person who wants to make an application for Legal Aid, it's important that they understand that there's a lot of information that's required in that application, and that it's important also to attach all of the financial details that are requested in the form, including information about their court orders and any other documents that might be asked for as part of the application form. Missing documents in an application for Legal Aid do cause delay, so it's really important for clients to ensure that they've included all of the documents and the relevant information when they're filling out the application form. And once it's filled out and all of the relevant information is attached, it can be lodged online, by mail, or presenting it in person at the local Legal Aid office. It's really important before making an application that you do get some legal advice so that you can understand the steps that you might need to take. And generally that legal advice will probably give you some information about how successful or otherwise you might be with the application that you're likely to make. So it's important to get legal advice prior to submitting a Legal Aid application if you can. I recognise that sometimes that's not always the case, particularly if it's an urgent matter, but in the general run of things, it's important to get legal advice. So I just wanted to give you some oversight of the funding guidelines for parenting cases at Legal Aid. So Legal Aid has got some requirements that they need to meet when deciding to provide funding for parenting cases, and they're listed there. In a general sense, Legal Aid funds vulnerable clients, and there's information required on the Legal Aid application which identifies that. There needs to be a dispute about a substantial issue. So it can't be something trivial. So if it's about a parenting dispute, it can't be, oh, we need to go back to court to determine whether or not changeover happens at McDonald's at Nanango or McDonald's at, I don't know, Harvey Bay. That's not a significant dispute. That's not a substantial issue. A substantial issue in a family law matter is likely to be about where the child lives rather than something small. whether or not the dispute is about the safety of a child and whether or not it's an application is required or application court is required because there's a concern about a child and the need for the child to be protected from harm. Whether or not the dispute in a family law context is about the denial of a safe and beneficial relationship between a parent and a child. So they're those disputes where maybe the child is not seeing the other parent and that's an issue that needs to be determined by the court. One of the other funding guidelines is that the dispute is around denying an Aboriginal or Torres Strait Islander child's right to enjoy their culture and heritage. And as you can see there, if there's been a significant change to the circumstances of a family which might justify an application to change any current parenting orders, that falls within the funding guidelines that Legal Aid has for parenting cases. So for property cases, the funding guidelines are set out there. There's asset pool restrictions. Amanda has spoken generally about that in terms of the dispute resolution service. But if there is an application to take a property case to the family court, Legal Aid's restrictions are that the asset pool needs to be between $20,000 and $400,000. The parties need to be married and, the parties were married and now are separated or divorced. If they were in a de facto relationship, they need to have been in a de facto relationship and separated for 2 years. And if there's a child of the relationship, there needs to be, in a de facto relationship, it needs to have subsisted for 2 years, and that if there is a child of the relationship and there's significant non-financial contributions, that also falls within the funding guidelines. And the application to court must be within the statutory time limits, which is 2 years from the divorce or the end of the de facto relationship. The other time when Legal Aid will consider a grant of aid is in particularly urgent circumstances where there is an imminent risk of disposal of the property. And this arises in when parties are separated and one of the parties may not be a registered owner of the property, and the party who is the registered owner appears to be seeking to either dispose of, sell or refinance the property. Legal Aid would consider granting aid to assist a client to ensure that they can safeguard the disposal or refinance of the property so that their interests are looked after in the proceedings. Over to Marie.
Thank you. Hi there, everyone. I'm here today to talk to you about the Referral Pathways program. So the Referral Pathways program is set up as a warm referral pathway for vulnerable clients who are experiencing domestic and family violence, family law and or child protection issues. It's for those who require timely legal advice, and in particular, those who may otherwise not have the ability or the capacity to self-advocate for legal support. So it provides a critical support system for these vulnerable clients, who might otherwise fall through the gaps. So clients who are referred through this process will get to speak to a lawyer within 1 to 2 business days. In order to have access to the warm referral pathway, an agency must be registered with the program. And in order to be registered, the agency must attend a training which is conducted by myself. In the training, you'll be guided through, what the process looks like, how you can refer clients in. You'll learn about the eligibility criteria, which is really important because we are targeting a specific client in this respect. And I also will always go through other services that Legal Aid can offer in the instance that your client perhaps is not eligible for the Referral Pathways program. So the benefits of the Referral Pathways program are to ensure that your client has access and can access priority legal advice services. The referral form has a section on it where you can provide critical information, background information, anything that's relevant to the client's current situation and circumstances. You know, essentially what is going on for the client at the time. By capturing that information on the referral, the referral form, you know, we intend to reduce any further barriers. We want to ensure that we're not re-traumatizing the client by them having to potentially retell their story over and over again. In a lot of cases, you know, these clients have kind of been through the ringer. They've probably told their story over and over to a number of different people. So by preparing, you know, you guys preparing that referral form, it kind of alleviates that. The client does not have to reach out to us at all themselves. So the referral form is then sent through to Legal Aid, where we then reach out to the client directly, firstly to book in for a legal advice, and then the solicitor would contact them within that 1 to 2 business days to provide the legal advice. So we just essentially want to make it as easy and as stress-free as possible for these particular vulnerable clients. So looking at very quickly the eligibility. So in order to be able to send through a referral for a particular client, there are 3 main factors that we need to take into account. Firstly, your client must present with at least one vulnerability, which may include things like capacity issues, cultural factors, homelessness. There's a whole range of things that client. Really important that the client, the advice that the client is seeking must be in relation to domestic and family violence, family law and or child protection issues. More times than not, there is a collation of maybe 2 or 3 of those together. And then lastly, very important to note that we are looking for clients who just lack that capacity to self-advocate. Anybody that you come across, or you may have a client that you can determine does have the capacity, we want to empower those people to reach out for themselves and to make contact with Legal Aid themselves. So we really are targeting a specific type of client in this instance. So in terms of vulnerabilities, Legal Aid has determined that there are a range of different types of vulnerabilities. That the idea is, as I mentioned already, you know, essentially it is that the client just does not have the ability to reach out themselves for whatever reason that be. I've listed on this slide some of those, you know, examples of what a vulnerability may look like. So as I said, you know, if your client can reach out for themselves, we want to empower them and make sure that they do that. Apologies. So looking at our agency partners, so probably not a great surprise that 87% of our registered partners are within the Domestic and Family Violence Service. So while we have an eligibility criteria for clients that are being referred through, we certainly don't have that when it comes to our agency partners and who can register. If your agency can determine that you may have clients that are coming through that would benefit from being referred through the Referral Pathways program, then we're more than happy to provide that training to you guys and get you registered so that you can start sending referrals through. As I've mentioned, it is important to note that, you know, an agency must be registered in order to send through a referral form for a client. We have referral pathways programs established in most of our regions. I think the only region that we don't currently have one in is Mount Isa. So we can assist people throughout the state. So what would basically happen is if you're interested in becoming registered and becoming a partner with the Referral Pathways program, as I said, you would attend a training. We would look at things like what does the process look like? how clients can be referred in. I will always go through the referral form and the importance of getting a consent from the client, and lots of other different things that we would look at. The training does only go for around about 45 minutes to an hour, depending on the size of the group and how many questions that may be had during that session. After the training, I would simply send you an invitation to register, and it is literally an email that says, would you like to become a registered partner? Once we receive a confirmation that you are keen to register with us for the Referral Pathways program, I would then send out all of the resources. So while the process is formal, the agreement or the registration is very informal. There's no forms and contracts and all that sort of thing to fill out. It is literally just, yes, we would like to register. And basically from that point, you guys would be in a position where you can start referring people through. So if after today you are interested, I've included my contact details. That's my direct phone number, so you won't be sitting on hold. And you can also email me as well if you're interested. I'll just note that in terms of the Referral Pathways program, you're not going to find any information on our public-facing website. And we do that for simply to ensure that basically the referrals that are going to be coming through are within scope. We need to ensure, as I mentioned, that agencies are attending a training session with me. So just reach out if you're interested. If you have other agencies that you deal with that you think may be interested, please feel free to give them my details. And I hope that I hear from some of you guys really soon. Thank you so much for your time today.
Thank you, everyone. That was great. So we'll open it up now for some questions. If you do have one, I would encourage you to pop it into the chat box. However, if you can only access the question box, I can check both of those. We'll just see if anything comes through. Otherwise, as well, if you think of anything post-webinar that you would like to ask our presenters, you can send that through to the webinars email. So that's just webinars@legalaid.qld.go.au. My gosh. And I'll send that off to the presenters, and someone from those teams will respond to your inquiry. I don't know if anything's coming through question-wise. So I might leave it open for another minute. If not, then we can finish today a little bit early. Okay, one question's popped through. Yes, you will receive a copy of the presentation slides. So about a week after this, you'll receive a link to the recorded webinar, and I'll pop the presentation slides along with those links that Marianne referred to earlier and anything else that might be that you can access or look. Okay, one other question. So if someone only meets one means tested area, i.e. within the income test, but exceeds the assets test due to the value of their house, would that mean they wouldn't be eligible for legal aid?
The answer is probably yes.
Yeah. Questions on grants of aid can be difficult too, because there's so much involved with whether or not, but that's another time too when you can certainly call up Marianne.
Yes, and there is information on the websites, at Legal Aid's website, about the means test that Legal Aid applies for funding somebody who needs assistance. So you just have to get onto the Legal Aid website and navigate to can I get legal aid, I think is the page, or enter that into the question box, and that should probably get you the information that you need.
Wonderful, thank you. So this question is, do the referring services use a template to send through the referral? So that's actually from our Legal Aid Council office.
Yes, so as mentioned, any agency that is looking to be a registered partner must attend the training. And as I mentioned, after that training, I would send through all of the resources. So that would include referral forms, authority forms, any other information that we may have discussed on the day, some brochures, a copy of an application form. So a whole resource pack, that will take care of that. And as I mentioned as well, at the training, I would very thoroughly go through the referral form to ensure that everybody understands, the different bits and pieces that are on there and the importance of filling the forms in correctly.
Wonderful, thank you. Were there any other questions before we sign off for today? I'll just give everyone another moment. So I might close off the questions now if everyone was happy. We can, as I said, please send them through to the webinars email. You can even respond when I send out the webinar recording and the slides if you have any follow-up for our team. But otherwise, just some basic information. So to contact us for legal information or referrals, the number there is 1300 651188. We do have a specialist line dedicated to Aboriginal and Torres Strait Islander information, and there is a separate line there for questions about an existing legal aid application. You can also, as heavily discussed by Marianne, thank you, we have a wonderful bounty of free publications on the Legal Aid website. You can pop on and have a look whenever you get the opportunity, and once again, they are all free and can be delivered straight to your organisation. So keep an eye out for our next two webinars. Because next month is Domestic and Family Violence Awareness, we will be operating two. So the first will be on the 22nd of May and the second on the 25th of May. We are just finalising the webinars, and they'll be available very shortly for registration. So if you are interested in those, I would suggest joining our mailing list or keep an eye out if you're already on there. Or looking at the Legal Aid website. So they will come out very soon, hopefully within the next week, few days. We'll have the registrations open for those. You can also watch any of our YouTube video, any of our webinars on our YouTube video. So that's just on the Legal Aid Queensland website. And that's kind of gone off, but thank you everyone for joining us today. Thank you to our wonderful presenters, and thank you to our interpreters. We hope you have a great afternoon. Thank you.
Thank you.